Good morning. As usual, a new legislation which was brought to the notice of Karnataka High Court regarding transgenders persons Protection and Rights Act 2019, which was brought into force 2020. Actually, what had happened? A boy who was born in the year 1983 registered his birth and certificate, birth with the authorities, and thereafter seems to have, due to some hormone disturbances, he was operated and became a girl. Therefore, he opted for an application. The disease, that means the boy was suffering from dysphoria, gender dysphoria, paragraph 2. Go through that also. And then they applied for change of gender in the birth certificate so as to take necessary changes of identity document, Aadhaar card, driving license, passports, etc. That was rejected by the authorities, stating that the Act 1969, Registration of Birth and Death Act, and the rules did not permit them to issue such certificates. So this was deeply discussed, and this judgment also discussed about the various provisions about the definition of transgender, and also you see at paragraph 10, paragraph 9, paragraph 10, the definition of transgender, whether they have undergone sex operation or not, if they are acknowledged as gender queer and person having such socio-cultural identities as Skinner, Hijra, Aravani and Jokta. That was the definition. Then the section 3 is there should be prohibition against discrimination, and section 4, recognition of identity of transgender person, read with some rules which permitted rules. Rule 3, how to issue application for identity of. Therefore, when it was challenged by writ, the Karnataka High Court, AR 2025, Karnataka 65, AR 2025, Karnataka 65, X versus State of Karnataka and another, had held that the authority rightly refused, because under the act which they are empowered to act did not provide, or there was an amendment how to issue such certificates after gender changing. However, finally, the court, after discussing and holding that there was no illegality, therefore it was correct, unless and until there was supreme. So the order finally passed was, until suitable amendments are made to Act 1969 and rules made thereunder, any certificate issued under 6 and 7 of the Transgender Persons Act 2019 by accepting and processing an application filed by transgender, if accompanied by a certificate issued under 6 or 7 of transgender, make such entries in the register birth and death and issue necessary birth and death certificate with modification made, indicating both the earlier name and the present name with the details of the certificate under section 6 or 7 being incorporated in the said certificate. So they have issued a direction to complete this. But actually, several things. What happened? Why these transgenders are very multiple in India, and particularly in Sultanate rulings? Because sultans used to have multi-number of queens, begums, and they want to maintain the mahal. That means exclusive for women queens. For multi-number of jobs, the male mighty labor is required. Therefore, they brought such laborers, and by castigating them, became the as uh, they were treated as uh, Aravanis, Hijra, Jokta, all those things. This way, because particularly Madhya Pradesh, Bhopal, and western countries where Muslim domination was huge, this transgender was slowly developed, and later on Bombay, they used to keep such transgenders for prostitution purposes because they have to maintain their woman prostitutions properly, and this way it is being encouraged. That apart, person's every persons were affected by this behavior of the transgenders in the rail, and while traffic signals, they used to abuse, beat, what are not. When you give some protections, the act should also restrict their behavior while mingling with the society. Best wishes.